Okay. Okay, thank you, sir. Let me see if they have follow-up. Do you have follow-up questions, counsel?
Yes, thank you, Your Honor. With regard to the backpack, did that have any significance, backpacks in terms of drug usage or possession of drugs in your police experience?
Yes, they're very portable. Usually have many pockets contained with them for, hiding purposes and whatnot. So it's very common for someone to use a backpack to transport narcotics or to hide them.
All right, and then when you see plastic baggies sticking out of the backpack, does that even give you more reason to think that there could be drugs in the backpack?
Absolutely, because they're normally used for the packaging for sale of narcotics.
Do you normally find plastic baggies, well, I'll strike that. I'll withdraw that question. No further questions, Your Honor.
Ms. LaFawn?
Was there any follow-up into the information that you had gained from Melissa Bradley's mother regarding this garage?
No, it had not been reported, and she said that the garage did not burn down, so there was no need to.
Okay, so the only information you had was from her?
Yes.
Did you talk to her or gain any information about when the last time was that she had seen Tyler?
No.
What about with Melissa? Any information on the last time she had seen Tyler?
She just kept talking to me how she was trying to get Melissa to leave him. She did not give a time frame or anything like that.
Okay, and when you talked to Melissa, did you get any information specific to time to make her information more reliable?
She had just said that he had his problems with drug use. No, there was no time frame or anything like that.
Okay, no other questions?
Thank you. Anything else, Mr. Robinson?
No, thank you, Your Honor.
Thank you, sir. You may step down. Mr. Robinson, any further witnesses?
No, Your Honor.
Ms. LaFawn, any witnesses for today?
No, Your Honor, thank you.
Okay, thank you.
Your Honor, may the witnesses be excused if they want to be.
They may be.
So your choice whether to stay or leave. Thank you.
Okay, arguments, counsel. Mr. Robinson?
Your Honor, we would mostly stand on our answer as far as the law goes. When counsel filed their motion to suppress, counsel mentioned several exceptions to the warrant requirement and said those weren't satisfied, but did not mention the automobile exception. And we believe that the automobile exception is the exception that most applicably applies here. It's kind of a funny way of saying that, but it applies. We believe that police had probable cause based on their experience, their training, what they saw, to believe that they would find contraband in that vehicle. The courts heard the testimony, heard all the reasons that have been given, plastic baggies that were seen in a backpack, furtive movements, a large amount of cash on him. Although they didn't count it right then, they knew that it was a lot of 20s and 10s. He's unemployed, he's a drug user, he's fled from the police before, and he's trying to flee again. The fact that he backed into that spot where he was, and instead of pulling in, would indicate, and then of course what he actually did would indicate an attempt to try to flee, hide, get away. So we would ask the court to find that the people have met their burden and that the evidence should not be suppressed. Thank you.
Thank you. Ms. LaFawn?
Thank you, Your Honor. Your Honor, I did not specifically talk about the automobile exception, but I did touch on the automobile issue with the case of Arizona v. Gant, and that also aligns with the case that I provided to the court and to Mr. Robinson today, People v. Short, which is 289 Mishap 538. It's a 2010 Court of Appeals case out of the state of Michigan. Both of those stand for the proposition that when an individual is arrested and a search is conducted incident to arrest, there are some guidelines that have to be followed when an automobile is involved, and Gant indicates that specifically the police may search the passenger compartment of a vehicle incident to a recent occupant's arrest only if it is reasonable to believe that the arrestee might access the vehicle at the time of the search or that the vehicle contains evidence of the offense of arrest. As it relates to that first caveat, whether it's reasonable to believe the arrestee might access the vehicle at the time of the search, I think it goes without saying that everyone here agrees that Mr. Oreskovich did not have access to the vehicle at that time. He was handcuffed, he was placed in a cruiser vehicle where he was unable to get out. So I think that we satisfy that aspect, Your Honor. And then the next question is whether the vehicle contains evidence of the offense of arrest. The offense that Mr. Oreskovich was being arrested for at that time was he had a warrant for fleeing and eluding. He also, I think the last deputy testified that he had a probation violation warrant, and I didn't see anything in the report to expand on any other warrants, but I think those were the nature of the warrants. The observations that the officers have indicated that they made did not pertain at all to the offense of arrest. I think that clearly, as has been testified to, the officers very easily could have gotten a search warrant in this situation. To go back, though, and talk about probable cause, which I think is what Mr. Robinson is saying, is they had probable cause, so they didn't have to get a warrant despite this case law, Gant and Short. You know, we've got a couple of things, right? They have these...
Ms. LaFont, first off, would you agree that the search incident to arrest exception is separate from the automobile exception?
I would,
okay.
Yes.
So even if Gant, neither of the Gant prongs apply, so they're not coming in the door under incident to arrest, separately there's the analysis of whether they have probable cause.
And that's what I'm about to go
okay.
to.
Thank you.
Yes. Again, the information that they have or had at that time, they indicate that they had information from Ms. Bradley's mother and from Ms. Bradley herself. It was a little confusing to me, but it sounds like about 3 weeks before this incident that Mr. Oreskovich was unemployed and that there were general statements made regarding drug use. None of those were verified. There was no further information or details into any sort of time frame or anything of that nature. So, you know, I think it's very easy to think that he could have gotten a job since that point in time. The furtive movements, I think, again, were described as the upper body leaning towards the left with no ability to see if he was reaching for anything or looking at something. It's not clear what that was. I know that I think the other point that was made was that he started to back his car up and they assumed he was trying to leave. I don't think that those things alone justify a search or justify probable cause to search without a warrant. I know we then got some testimony that is frankly new as of today that there were objects in plain view that could have bolstered that probable cause. And I would ask the court to, you know, give maybe less weight to those because again, that's not how it was stated in the police report. The other issue obviously is the cash. I think everyone testified they had no idea how much money was there, that there were some 10s and 20s. But no one knew how much it was. Nobody counted it. Nobody shared that information prior to the search being conducted. I think no matter which exception it tries to come under, I don't think that the search was reasonable, nor do I think there was probable cause, and I think that the evidence should be suppressed. Thank you.
Thank you. Mr. Robinson?
Nothing further, Your Honor. Thank you.
Okay. Okay, so Mr. Oreskovich here is arguing that the search of his vehicle was unconstitutional as not falling within an exception to the requirement that the government obtain a search warrant prior to searching. Prosecution argues that the totality of the circumstances gave police probable cause to search his vehicle for illegal controlled substances, hence the automobile exception. Alternatively, I believe the prosecution is arguing that under Gant and Tavernier, the officers could search incident to arrest, not because the arrestee was within reaching distance of the passenger compartment of the car, but because it was reasonable to believe the car contained evidence of the offense of arrest. I'm not persuaded by this second argument tendered by the prosecution for the reasons noted by Ms. LaFond, that there's no support that they would have found any evidence of his previous fleeing and eluding when searching this car. I think the testimony was even that this was a separate car. I do, though, find that the search was justified by probable cause and the automobile exception. An officer may search an automobile without a warrant if the officer has probable cause to believe the vehicle contains items the officer is entitled to seize, such as contraband or evidence of a crime. When there is probable cause to believe that a vehicle contains items subject to seizure, officers may search every part of the car and its contents that might contain those items. Probable cause to believe that a vehicle contains narcotics will justify opening containers that could contain narcotics. Probable cause to search a car exists when the totality of facts and circumstances indicate a substantial basis for believing there is a fair probability the search will uncover contraband or evidence of a crime. In ascertaining the circumstances, an officer may make reasonable inferences based on his or her experience. Indeed, a reviewing court must examine the officer's observations in light of her experience and training, not in a vacuum or from a hyper-technical perspective.